Welcome back to Organized, the business law breakdown. And in this new season, we're going to be mastering limited liability corporations, or LLCs. LLCs are a flexible new entity type. And in this episode 1, we're going to describe what is the LLC and talk about the journey we'll take over a 10-episode course this season. So many modern businesses, ranging from single-member startups to large-scale real estate ventures, are choosing the LLC form, and we'll discover why. LLCs blend liability shields of a corporation with the fluidity of a partnership, and thanks to some tax law that makes them very appealing, we're going to see how they give almost endless contractual freedom. Now, before we even jump in, you might think, everyone should choose a form which provides the most freedom. But that's actually not always the case. Think about going into a store and deciding whether you're going to buy a pre-made suit jacket or a dress, or a bolt of cloth and a pattern. While you might get something that fits better by buying the cloth, it's a lot more work to custom tailor it. And over years, many businesses fit well into the off-the-rack solutions that corporations, partnerships, and other forms offer. So LLCs aren't always the right answer just because they're flexible. That said, they have huge potential, and we're going to talk about them this season. Picture two friends launching an e-commerce side hustle. They want a few features. They want personal liability protection. Neither wants to be responsible for the debts, and for that matter, the torts of this business. But they hate corporate rigidities. If you form a corporation, you have to elect a board of directors. You have to issue shares of stock. You have to have annual meetings. Corporations also are taxed as entities, and they may prefer pass-through taxation to avoid the double tax of a typical C corporation setup. You could file as an S corporation, but there are extra details there as well. And so we enter the LLC. The limited liability company is a legal innovation that's transformed American business law over the past few decades. Historically, if you wanted limited liability, your best option was a corporate form. But these are thick with formalities, and as I mentioned, double taxation, unless you qualify as an S corporation, which has some limitations. Partnerships are simpler structures. You don't even need to file to form one. But partners are personally liable for business debts, and that includes the debts that others cause. In the 1980s and 1990s, states started authorizing limited liability companies through a new statute, mainly built around the Uniform Limited Liability Company Act, produced by the American Law Institute. And as a result, many states adopted similar LLC structures. However, they didn't take off just yet because, as we'll see on our journey, we needed some tax rulings that really governed and gave some confirmation around how these be taxed. But this is an example of a legal innovation, a new legal technology where states, especially states outside of Delaware that were competing to be havens and homes for businesses, created new laws in order to cater to a different type of business. Just by the way, we'll talk about this in a future season, but one thing I'm really excited about is how many states are doing this again with decentralized autonomous organizations, or DAOs. And it's one area that I specialize in researching. I think we're going to see another revolution as states allow DAOs to form, just like limited liability companies provided a new way for businesses to form and became very popular. Anyway, sometimes I'll talk about the Uniform Limited Liability Company Act, or ULLCA, and that refers to the limited liability law in most states as it's been adopted. Section 108 of the ULLCA refers to an LLC as a hybrid between a partnership and a corporation, and it's designed to modernize small business structures. And by the way, the reason that I teach LLCs after I teach partnerships on the one hand and corporations on the other is I think the easiest way to understand this hybrid is to understand these component parts of which it were made. It has features of a corporation, features of a partnership. So if you haven't actually listened to the seasons on partnership and corporation, you might pause here and go back to those, because I think it's fundamental to understand what are those polar extremes And that way we understand how a limited liability company mixes and matches elements of both. Let's talk a little bit of statutory history. Wyoming, which also has innovated with one of the first DAO statutes, passed the first LLC statute back in 1977. And it fueled a wave of imitators. Once IRS ruled, in IRS ruling 8876, that LLCs can enjoy partnership-style pass-through taxation simply by checking a box and electing partnership taxation. That means that it doesn't matter whether an LLC is actually designed to be governed like a partnership. You can govern an LLC like a corporation. You could have a board of managers that functions like a board of directors. But so long as you check the box, you can be taxed like a partnership. No dreaded corporate double tax. This is a huge innovation, a huge development that allowed this innovation to really take off. And today, every state has an LLC statute. Most are modeled on that Uniform Limited Liability Company Act. I'll also mention that some have innovations beyond that, like some states allow series LLCs, and there are other flavors we can get into when we talk about advanced topics. But again, most states have some version of the Uniform Act. And that includes limited liability. Under ULLCA Section 102.8, members are shielded from personal responsibility for the LLC's debts, similar to shareholders in a corporation. So if that e-commerce venture racks up supplier debts, members' personal assets remain off limits, unless, of course, there's room for piercing the limited liability company veil. In a future season, we'll talk about piercing the corporate veil. The same concepts apply to piercing the limited liability company veil. The reason I talk about that later is because those piercing concepts relate to all the entity forms that we'll discuss. Piercing is the limit to limited liability. Although you enjoy limited liability so long as you comply with the law does allow for shareholders' assets to be targetable in litigation under certain conditions. So just kind of put it in the back of your mind, there's a concept called veil piercing, and it applies to LLCs and corporations too. But for the most part, so long as you observe corporate formalities, the shareholders, or in this case, the unit holders, enjoy limited liability. The second is pass-through taxation. Corporations are generally taxed at the corporate level. There's a concept called S corporation, which we talked about in our season on corporations. But in general, corporations pay corporate tax, and then they make distributions or dividends to shareholders, which are also taxed. This is known as double taxation. But with an LLC, you can treat it like a partnership so that the entity is disregarded from an IRS perspective. And this allows what we call flow-through taxation. It literally flows through to the partners who report the income or losses on their personal returns. They get a K-1. This check-the-box approach is critical based on IRS ruling 8876. And corporations, again, they don't check the boxes easily, as corporation requirements are stricter. It's still an option. I will mention here briefly, talk about tax later too, that flow-through taxation is not always a good thing, because when you disregard the entity, the profits are attributed to the members, whether or not there's an actual distribution. So one challenge that comes up with pass-through taxation is phantom income. You might have to report income to the IRS, even though you don't get cash to pay it. We'll deal with that one later as well. Let's go to the third element of LLCs, which is crucial, contractual flexibility. The LLCs have an operating agreement, which is a contract between its members and its managers that can shape the business almost any way the members want, except they can't be run by algorithm. And that's where the DAO innovation comes in. DAO LLCs are even more flexible, where you can actually govern an LLC with an algorithm or with some type of governance structure based on tokens and blockchain. Again, a future topic, pretty exciting, but LLCs, the conventional ones, back in 1977, no one was thinking about blockchain. And so you did need human beings to govern the company. They could be members or managers. And beyond that, you can allocate profits, you can allocate losses, you can allocate governance in all sorts of super flexible ways. And so LLCs need some kind of operating agreement that defines all these things. And ULLCA Section 104 emphasizes that the state has default rules that only apply if the members don't override them. Corporation law generally is more formal and more constrained by corporate code. So if those off-the-rack solutions are hard to tailor to meet your needs, an LLC can be a better fit. In addition to choosing corporate form, of course, business creators can choose the state of incorporation. And thanks to the internal affairs doctrine, the state of incorporation will govern the internal affairs of the company. So if you form an LLC in Delaware, you can do this even if you live in Texas. You can form an LLC in Delaware no matter where you live, in fact. You'll be governed by the Delaware Limited Liability Company Act. And you'll be subject to the Delaware courts regarding your internal affairs. And this can be an advantage because the Delaware courts have extensive case law paralleling its corporate jurisprudence. So if you crave robust legal precedent and you want to avoid the kind of uncertainty that can come up in a smaller jurisdiction that just has less case law, Delaware can be a prime pick even if you don't choose a corporation. It's worth noting that Delaware has its own Limited Liability Company Act that doesn't fully track the Uniform Act, and other states might have other features you prefer, like as I mentioned, you could have series LLCs, which are useful especially for real estate ventures, and there are some states that have more advanced forms, and I alluded to them earlier, like in Wyoming, you can have a DAO govern your LLC. They always seem to be on the cutting edge of corporate innovation. So there are reasons not to choose Delaware, but there are reasons to choose it for legal certainty. And I also just want to mention that the IRS ruling 8876 really supercharged the LLC movement because, just as a historical anecdote, prior to that, you would be taxed like a corporation if you had corporate characteristics, like corporate management. But again, after this ruling, you just check the box, and then you can run it however you want, and you'll be taxed in a consistent way. Today, LLCs outnumber newly formed corporations in basically every state, underscoring how profound legal certainty is when it comes to forming corporate forms. Now that I've introduced you to the core appeal of LLCs, which include a flexible structure, limited liability, and potential tax perks, I hope I've motivated you to stay with me for the next 9 episodes of this particular season. In episode 2, we'll dive into formation, covering how to file the certificate of incorporation, or I should say the certificate of organization, under ULLCA Section 201. And we'll talk about the crucial role of the operating agreement. There are pitfalls if you rely on oral agreements or implied terms. So we want a well-defined operating agreement. Talk about that in episode 2. In episode 3, I'll call Management Wars. We'll discuss member-managed versus manager-managed LLCs. We'll talk about the default rules and how to navigate possible management conflicts. In episode 4, I'll take a deeper look at that operating agreement's design, going beyond formation to some of the more technical aspects of voting thresholds, allocations, and what are manifestly unreasonable terms to avoid accidental ambiguities and unenforceability in an LLC operating agreement. In episode 5, we will dissect ULLCA Section 409 to discuss to what extent members can modify fiduciary duties. So one thing that's super interesting about LLCs is they're, as I said, very flexible. They're even flexible in terms of waiver of fiduciary duties. We learned in our chapter on corporations that managers owe a duty of care and a duty of loyalty. The duty of loyalty can't be waived in a corporation. The duty of loyalty kind of can be in an LLC. Kind of interesting. Stick with me on episode 5 to talk about fiduciary duties in LLCs. Episode 6 preludes veil piercing. Like I mentioned, veil piercing is a larger topic on its own, but we'll talk about it here as well. When the LLC shield fails, when we have a single member that is potentially commingling assets, we might have issues that don't allow that person limited liability. In episode 7, we'll talk about the end of the LLC, not of the form itself, but of the organization in particular. It can end through disassociation, dissolution, and deadlock. And if you've been following me so far, you'll notice I'm using terminology from partnership law. So those concepts apply here as well. Hopefully you listen to that season because we'll be reviewing that here. There could be voluntary or judicial dissolution under ULLCA Section 701, and we'll talk about some memorable cases. But again, this really draws from partnership law, so hopefully we listen to that season already. In episode 8, we'll talk about mergers, conversions, and entity transformations because LLCs can become corporations, and in fact, corporations can become LLCs, although there are tax consequences when you shift, and we can also merge them together. Sometimes startups will start as an LLC and become a Delaware corporation when seeking venture finance, and this type of conversion is an interesting and important transaction in the startup lifecycle. In episode 9, we're going to move to advanced frontiers. I've been preluding some of them. Here I'll talk about series LLCs, DAO LLCs, professional LLCs, and how states are experimenting with decentralized, distributed governance. I know it sounds fancy, but it's actually here. Blockchain governance is already happening in corporations in America today. And finally, in episode 10, I'll provide some comparative insights that will kind of capstone this whole module on our season on partnerships, corporations and LLCs. I'll focus on entity choice, and now that you understand all of these things, we can make strategic decisions given a business scenario. In short, by the end of this season, you'll grasp why LLCs have become a go-to choice for countless entrepreneurs and established businesses alike, and perhaps you'll also know when not to choose them. So I'll see you in the next one, and for now, I'm Professor Seth C. Oranburg, and this is Organized, the Business Law Breakdown. Welcome back to Organized, the Business Law Breakdown, and our season on mastering limited liability companies. I'm Professor Seth C. Oranburg, and as a reminder, in our last episode, we explored the formation of an LLC from the very simple certificate or articles of organization to the much more complex act of drafting an operating agreement that explains each member and manager's roles. In this episode, we're going to dig deeper on how the LLC will be run by members or by managers, which makes them more partnership-like or more corporation-like. These hybrid entities can function like either, or in some ways, both. We're going to dig into Uniform Limited Liability Company Act Section 407, look at statutory default rules, and importantly, the consequences of choosing member-managed and manager-managed structures. Say that 3 times fast. Manager-managed, member-managed structures. Right. We'll look at 2 of the high-profile cases, and we'll illustrate how management disputes unfold in real life. So, let's see how you decide who's in charge, because this can make or break LLC success. Picture this. You form an LLC with a handful of friends. You all want an equal say in day-to-day decisions. You plan to sit around a table like equals, and no matter whether someone gave $10,000 or $100,000 in capital contributions or provided a valuable patent, everyone has an equal say in the business. That looks like a partnership. But what if that LLC eventually grows and you get some outside investors who you don't want to have a seat at the table, provide $1 million of investment? Well, democratic voting can get cumbersome in those cases, especially with a silent investor who wants minimal involvement, and so you may want to hire a professional manager for day-to-day tasks. And so the governance of an LLC might change over time and really should reflect the realities of how you want the organization to function. So while this sounds like a technical box-checking exercise, this is really something we might think about. And the easiest way to understand it, and I've said this before in this season, is to understand partnerships on the one hand and corporations on the other. In a partnership, we have people who sit around a table, and we basically take a head count. How many are in favor? Raise your hands. 3 out of 5, motion passes. In a corporation, we care about how many shares of stock you have. There could be 5 people at the table, but if one person has 100,000 shares of stock and the others have 5 each, one person decides everything. So the way that we set up the structure depends on how we want it to run, and we can make it more like a corporation or more like a partnership. And importantly, corporations are useful because we have professional managers. We basically offload the managerial responsibility to people that run the day-to-day tasks, or at least appoint the people who do in a very large corporation, while shareholders remain passive. In a partnership, typically, the partners are very actively involved in the business. In an LLC, the lines can blur, and the flexibility gives you freedom, and with freedom comes responsibility to decide who holds the reins. But that freedom sparks conflicts if members have differing visions, or if a manager oversteps, or if your operating agreement is ill-defined. Under Uniform Limited Liability Company Act, Section 407A, the default rule is an LLC is member managed. So if you don't write anything else, you run like a partnership. Each member has an inherent right to participate in running the business and make ordinary business decisions. Typically, as a default, major decisions need a majority or a unanimous member vote, again, unless the operating agreement says otherwise. Once again, the operating agreement should say something. Even if you want to adopt the statutory default, my advice is that you put it in the operating agreement so everybody knows what are the governance rules. In a member-managed LLC, each member can act on the company's behalf, just like in a partnership, where a partner can go and bind the company in ordinary affairs. Again, that's true unless the operating agreement restricts it. If you don't want members to be able to bind the company, you should select a manager-managed LLC. That would inherently limit members' powers to bind. Otherwise, it functions again like a partnership where the members have rights to enter into contracts on behalf of the organization. Suppose you have 4 members and each have 25% ownership. Unless your agreement sets unique voting thresholds, everyone has an equal say. And that's still true if they have different ownership. Again, the default is it functions like a partnership. You don't vote with your shares, you vote by number of members. But it's very important to specify this in the operating agreement. I'm going to sound like a broken record by the time we finish that, but hopefully I motivate you to start looking at operating agreements seriously, because we may want to allocate voting power based on ownership, based on role or responsibility, based on membership, or based on something else. It's important in particular when we have 2 people, because 2 people can disagree and you risk gridlock or confusion if membership is not separated from governance in any meaningful way and you just have a 50-50 vote. You need some kind of tiebreaker situation. In terms of liability, remember that it's an LLC, so we have limited liability to outsiders. But what duties do people owe to each other? As a default, in a member-managed LLC, the members owe a duty of loyalty and duty of care to each other. That means that if you're a member, even with only a few shares, a few dollars, a few percentage, a little bit of the ownership or units of an LLC, you can't engage in a competing business. And people might be confused by this. Let's say you have an opportunity to invest in a golf course, and you invest $100,000 in a golf course that costs $10 million. So you're basically a 1% owner of this golf course. If this is a member-managed LLC operating under default rules, you can't invest in another golf course without clearing some of the duty of loyalty concerns. This is totally different than if you bought a share of stock. If that golf course was a golf course corporation and you bought 1% of that corporation, feel free to buy 1% of some other golf course somewhere else, or start a competing business, or purchase the land nearby. But if you are a member of a member-managed LLC, you have a duty of loyalty to all the other members and to the LLC itself. So you have to refrain from self-dealing, and you have to manage competently. So you have responsibilities. You can't just say I'm a passive shareholder, because under this structure, everyone's actively responsible for the LLC's success or failure. So if you have a small team that trusts each other and everyone intends to participate, a member-managed LLC can work very well. But when not everyone has the same time, skill, or willingness to manage the business, not only can friction arise quickly, but this advantage of having everyone have a seat at the table becomes a liability risk. and might limit people's ability to engage in competing business in ways they didn't intend and don't expect, in which case we might want to designate a manager. ULLCA Section 407C allows the designation of a manager-managed LLC. Here, a named manager or multiple managers or a board of managers, like a board of directors, takes charge of the day-to-day operations. And they're the ones who owe the duties of care and the duty of loyalty. Non-managing members then take a more passive role, much similar to shareholders or limited partners. And again, the model here is like a board of directors without corporate formalities, or at least with fewer corporate formalities. The operating agreement typically requires a majority vote of members to appoint managers, but again, we could change that. We could have a supermajority or unanimity. The same body can generally remove them, again, unless the agreement has special protections, like supermajority votes or some kind of staggered board. Told you, broken record, it's flexible. You can design it how you want. The key thing is that in a manager-managed LLC, the members are intended to be passive, and they don't have fiduciary duties of care and loyalty in the same way that they would if they were partners or members in a member-managed LLC. That's the key difference. It's the manager who has to abide by the fiduciary duties he owes them to the LLC and as a flow-through to the members. However, shocker, LLCs are more flexible than corporations. So, in corporate law, you can't generally waive the duty of loyalty. You can, to a certain extent, waive the duty of care through 102b6, which came after Smith v. Van Gorkum, if you remember that series of lecture. But in an LLC, you actually can limit a manager's liability, even for breaches of duty of loyalty, so long as they're not, quote unquote, manifestly unreasonable. You can look at the case of Freely versus NHAOCG. It's a well-known case where a manager tried to disclaim broad obligations. The court allowed the operating agreement to be modified in ways that actually did limit the manager's liability, but also questioned how far this could go. Some states, some courts will say you could basically disclaim the duty of loyalty and the duty of care completely, but it's not clear to what extent this could be pushed in extreme cases. Again, this might be popular when you have silent investors or a larger membership base that doesn't want daily operational tasks. And managers may be more willing to take on the role if they can engage in other opportunities that could be seen as conflicting. So let's talk about two of the well-known cases. The first is the one I mentioned earlier, Freely versus NHAOCG. This is a manager-managed LLC. The manager tried to disclaim fiduciary obligations in the operating agreement, and the court agreed that ULLCA Section 105D3, which, by the way, has a similar state variant in most states, allows modification to the duty of loyalty. The limiting factor is whether they are manifestly unreasonable. Now, of course, the court did not declare what manifestly unreasonable means, but it sounds like a pretty big scope that we could disclaim in many cases. So the manager has some measure of accountability, and the case does say that we can limit the liability of managers, but we can't eviscerate them entirely, but we don't yet really know what manifestly unreasonable means. In another case, McConnell versus Hunt Sports, a group of investors invested in a member-managed LLC. They wanted to bring a professional sports franchise to Columbus, Ohio. In this case, again, a member-managed LLC, one member engaged in side negotiations, arguably going against the LLC's interest. And the court had to address whether he breached his fiduciary duty of loyalty and found that he may have. The result underscored that members in a member-managed LLC have duties not to undercut the venture. You can't usurp an LLC opportunity, even if you see yourself as a passive investor, if you're structured as a member-managed LLC. Even if it's not a corporation and you're not a director, members of a member-managed LLC can't do side deals that sabotage the LLC's collective goals. If you want to have that kind of freedom, consider a manager-managed LLC and don't be the manager. Together, these examples highlight how management structure affects who owes duties to whom and how courts interpret breaches. No matter what structure you choose, ULLCA Section 409 sets baseline fiduciary duties of loyalty and care. In a member-managed LLC, each member owes duties to each other and to the LLC. You can't take corporate opportunities if you're a member in a member-managed LLC. In a manager-managed LLC, only managers owe these duties. Non-managing members typically don't. But again, watch out. Read your operating agreement. The operating agreement prevails. Even if something is nominally called a member-managed LLC, we could limit the fiduciary duties of members to each other and the LLC. And even if it's called a manager-managed LLC, we could ascribe some kind of fiduciary duties to members. The operating agreement is super flexible, which means you have to read it. So that's the 411 on member-managed versus manager-managed LLCs. The default is member-managed, where each member plays an active role and has duties of care and loyalty. But a more centralized approach, where there is a manager who has those duties of care and loyalty, is also an option in these states. Just remember, these choices shape fiduciary duties, voting rights, and everyday accountability. And again, the operating agreement governs this. So in the next episode, we will do a deep dive into that operating agreement. We'll explore some do's and don'ts of drafting these operating agreements. And we'll talk a little bit more about how to think through some of the major levers that we have to decide in these flexible structures. Until then, I'm Professor Seth C. Oranburg, and this has been Organized, the Business Law Breakdown.